Tech giant Google is on trial this week after the US Justice Department brought a claim against the company stating they used their power to monopolise online search services. The US government argues Google unlawfully stifled competition by paying billions of dollars to ensure its search engine would be the default on most phones and web browsers. Google maintains it didn't violate antitrust laws. Well, today, a US District Court judge for the District of Columbia will begin considering the arguments in this case. And we can cross live now to Laura Phillips-Sawyer, Professor of Business Law at the University of Georgia in the United States. Good to talk to you. How important is this case?
Well, this is a monumental case in American antitrust law, especially in the domain of monopolization. This is the first time we have seen a case like this against a big tech firm in over 20 years. The most important one preceding this one being U.S. versus Microsoft, which was settled in 2001. And that case, of course, ended in a consent decree that required Microsoft to open up its operating software to competing browsers like Netscape. So a lot of people are looking for, will this case have a similar sort of outcome? Will it be settled? Will we get precedent? And will it require more competition in this market?
And what's the answer? I mean, should Google be worried right now, do you think?
Well, the Department of Justice has brought a really strong complaint that is based on very standard anti-monopolization procedures. And the case looks strong. When you look at the type of contracts that Google has with Apple and Mozilla's Firefox, the revenue sharing agreements for web browsers, which makes Google search the default search for those web browsers, and requires that Google pays upwards of $12 billion a year to Apple. But that's just one part of this conduct that's alleged to be anti-competitive. The other part of that are these Android agreements, which you mentioned just a moment ago. And with those agreements, Google has gone to original equipment manufacturers like Samsung. They've gone to carriers like Verizon. And they've said, if you want Android on your phones, then you need to put all of our 11 proprietary apps on that phone as a default on the home screen, prominently located. And they say, now this is a little bit different than Microsoft. They say, we're not going to insist that you do not pre-install any other default. However, if you want part of that revenue sharing agreement, then you need to refrain from adding any default search engine that might be comparable to Google search. And so what the department is alleging is that those contracts, when pushed out by a firm with market power like Google, actually has the effect of excluding competitors, creating barriers to entry, whereby consumers are harmed because we're stifling competition.
Laura, it's good to talk to you. Laura Phillips-Sawyer, thank you very much indeed for explaining that to us so clearly.